Hello and welcome back. So we're looking in this lecture at the building blocks to form a contract, and the key element there is an offer. So what exactly is an offer? Well, there's a definition here for you. An offer is a definite promise made by an offeror to be bound on specific terms. Okay, so a definite promise, so once you've made your offer, if that is accepted, you will be bound by it. And it sets out the terms of which you're prepared to accept. Now, there's been a lot of case law about what exactly is an offer, because only something that meets that definition of an offer can actually be accepted and form that agreement that gives us the building blocks for our contract. So, the cases have said an offer must be certain. It must be clear what is the price that you're offering, what are the goods that you're offering, and what are the terms? When are you going to deliver them? Are you going to include delivery? Does your offer include fitting or setting up of the goods, assembly of the goods? It's really important that you can understand exactly what the offer includes. And there is a very famous case where an offer was made to buy the horse if it is lucky. And it was held that that was too uncertain. What horse? Lucky at what? So if you ever see a question that uses that scenario, that is not an offer. It's too uncertain. So I'll buy the horse if it is lucky. Now, the examiner loves something called an invitation to treat. Now, an invitation to treat is not an offer, and therefore it cannot be accepted. So it can't give you the basis of a binding contract. So the examiner will often expect you to be able to identify an invitation to treat and distinguish it from an offer. So what are the examples there? Well, advertisements in a newspaper. So someone puts an advert in a paper that says, I promise to sell my car for, and then there's a typo and it says they'll sell it for £10 instead of £10,000. Well, you might like to think that you can then accept that offer, rush off and buy that car for £10 because, even if it's a scrap heap, you really wouldn't mind buying it for a tenner. But actually, no. The owner can say, actually, that was a mistake in the advert. I don't want to sell to you, and I'm not bound to do so because I didn't make an offer to sell. I made what's called an invitation to treat. Therefore, when I placed that advert, I was inviting people like you, customer, to come and buy my car. Goods displayed in a shop window. So if you have a display in a shop, and again, something is maybe mispriced, or maybe something on the self-service shelves in a shop. So again, if you go into Tesco and they have a whole stack of iPads priced up at £50 each, you can't fill your trolley with those and insist on buying them. When you get to the checkout and you put your goods on the conveyor belt there, you are making an offer to buy those goods in response to the invitation to treat made by the shop. Okay, so you can't force them to sell at £50. Now, quite often shops will honour a sale of goods where they are mispriced, and sometimes that's just goodwill, sometimes it's just that they haven't trained their staff properly. Now, the case that's mentioned there, Fisher v Bell, is quite an interesting one. This was a guy who offered a flick knife for sale, and he was charged under the Offensive Weapons Act with offering an offensive weapon for sale. However, he got off, and the reason he got off this case was because he said, I didn't offer anything for sale. I was merely making an invitation to treat. The goods were in my shop window with a little price tag attached. Therefore, I made an invitation to treat. The person who came into the shop was making an offer to buy that flick knife at the suggested price, and because of that he couldn't be convicted of the offence of offering offensive weapons for sale. Other examples, circulation of a price list and an auction. Now, if you've ever watched Homes Under the Hammer, you get the auctioneer will shout out the price, and the person in the audience will just indicate that they are prepared to make an offer at that price. The offer comes from the bidder. The acceptance comes when the auctioneer bangs his hammer. But the actual offering the items, listing the items for sale at the auction, that is an invitation to treat. Okay, so that one is a pretty important topic, frequently tested in the exam. So, returning to the characteristics of an offer now. Now, an offer can be made to one person. It can be made to a group of people. or it can be made to what we call the world at large. So that means I could offer to sell my car to you, I could offer to sell it to any of my principles of law students, or I could offer just anybody who wants to buy it. So the lead case here is a very famous case called Carlyle v. Carbolic Smoke Ball Company. Now, this was all based on an advert, and if you bear with me a second, I'll show you the advert. Now, here it is, and you can see from this advert that it's clearly quite a while ago. And what happened was the Smoke Ball Company invented a product which they said cured pretty much anything: cold in the head, coughs, catarrh, asthma, bronchitis, sore throat, everything, look, snoring. And what they said was, we're so confident with our product that if you use it and then you catch the flu, then we will give you £100 reward. Now, they went on and they said down here, £1,000 is deposited with our bank as proof of our good intention in this matter. And the court was very influenced by this statement, because what happened was Mrs. Carlyle bought the carbolic smoke ball and used it according to the instructions and then caught the flu. So she went on to claim her reward. And Carbolic Smoke Ball Company tried a lot of arguments to get off the hook on this one. And one of the arguments that they raised, the first one, was that they hadn't made an offer. They said, we haven't made an offer because this was too big. This was just an offer to the world at large, and an offer, they said, has to be specifically addressed to one person. Well, the court said no. They said, so long as the terms of the offer are sufficiently precise, you can make an open offer to anyone in the world who cares to accept it. Now, it's not quite as important at this section, but we'll just go on while we're talking about Carlyle. Because the other thing they said is that, this wasn't an offer at all. It was just advertising pluff. It wasn't intended to form the basis of a legally binding contract. And it was this phrase here that the court were affected by. They said, well, actually, no, the way you've worded that advert suggests that you did intend to create a contract here. So they tried one more argument, which is something we'll come on to later on in this chapter. And they said, well, Mrs. Carlyle never told us that she was going to accept our offer. She never communicated her acceptance. And the courts again said, no, in an offer like this, in an open-ended offer to the world, the fact that she has bought the product and started to use it is sufficient to constitute acceptance. And we'll see that point again later. And you need to be careful also with an offer. An offer isn't the same as negotiation. So if someone asks you, for instance, what you would expect to sell your car for, and you reply to that, that is not the same as you offering to sell your car at that particular price. Now, once you've put your offer out there, you're now starting to realise that as soon as that offer is accepted, you might have a binding legal contract. So you want to be able to change your mind sometimes. And you can do that. You can terminate your offer, or your offer might actually be terminated by the sequence of events. So let's have a look at that. First of all, rejection. So I offer to sell my car to you. You say no. That's it. You've killed my offer. That's it. It's gone. My offer cannot now be accepted. So if you then change your mind tomorrow, you can't come back and accept my original offer. What would happen then is that you would be making a new offer to buy my car this time, which I can either accept or reject. Now, similar to that is a counteroffer. So a counteroffer is where I offer to sell my car to you, perhaps for £20,000, and you come back and say, well, actually, I do like your car, but I'm only prepared to pay £15,000 for it. What you've done there effectively is you've said no, and you've made a new offer. And that new offer is something which I can decide whether I want to accept or reject. So if you like, we've changed places. You have become the offeree and the offeror, and I have become the offeree. So a counteroffer, again, pretty common in the exam questions. And there's a very famous case there to illustrate the fact. So in this case, Wrench, the defendant, offered to sell property for £1,000. The words D and C there. D is defendant, C is claimant. So in this case, the claimant is Hyde and the defendant is Wrench. So, Wrench offered to sell property for £1,000, but 2 days later C replied and said, well, actually I'll buy it for 950. And D said no. So what happened there when when C made his offer to buy it for 950, that was a counter offer, and D rejected it. He said no. So this original offer is now dead. The counter offer has been made but also rejected, so that is also now dead. So C, the claimant, then went back and said, well, okay, I'll pay 1,000 then. He couldn't do that because there were no outstanding offers that he could accept. What we actually have there is a further offer, a new offer that C has made, and it's up to D whether he accepts that offer or not. So it's really important when you get questions that test this, that you work out who's made an offer and whether that offer is still open for acceptance or not. Now, when we're looking at counteroffers, the examiner likes to look at what we call a request for information. Now, these are different to offers because a request for information is not a counteroffer. Therefore, it doesn't kill the original offer. So let's have a look at this example here, Stevenson versus McLean. In this case, McLean made an offer to sell some iron. And he gave a price, 40 shillings per net cash per tonne, open till Monday. And the claimant said, well, could you spread the delivery over 2 months? He didn't get a reply, and therefore he accepted that original offer. But in the meantime, the defendant had sold this iron to someone else. So the problem there was whether or not that original offer was open, because if C's inquiry had been a counter-offer, that original offer to sell would have been terminated and therefore not available for acceptance. If C's inquiry didn't amount to a counteroffer, then D was not free to sell that iron to someone else. He needed to stand by his original offer until Monday. So the court looked at this, and what they said was this wasn't a counteroffer. This was simply an inquiry about the terms of the contract, not a counteroffer and not a rejection, and therefore McLean, the defendant in this case, was in breach of his contract with Stevenson. So you need to be very careful with that, and it's not always easy to tell when something is a counteroffer and when it is a request for information. And the exam smart there is quite helpful. Look at the words used in the question. If the offeree responds with something like, I will only buy if you do X, Y, and Z, then that's likely to be a counteroffer. But if he's asking a question, would it be possible to delay delivery, for instance, that is more likely to be an inquiry. So look at the tone of the words. Also, look at how significant the request is. Does it change the terms of the original offer? If it mentions price or the subject matter of the goods, the quantity of goods, then it's much more likely to be a counteroffer. So how else might our offer come to an end? Well, lapse of time. Your offer, once you've put it out there, eventually it will die its own death. It will come to an end. And the problem is, when? The courts have said a reasonable period of time, and what a reasonable period of time is will depend on the subject matter of the goods. For instance, if it's something like fresh cut flowers, it's going to be a very short period of time because, the flowers won't last. If we're talking about a property, well, it's probably not going anywhere. It's more reasonable for the offer to stay open for a longer period. And the case that's mentioned there, the Ramsgate Victoria Hotel case, this was a case where a shareholder had made a request to purchase shares in a company. So the company had issued a company prospectus, which is an invitation to treat, and the shareholder had replied, offering to buy some shares, and that the shareholder's reply was an offer. Now the company didn't reply, and I think it was just under 6 months when the company replied and cashed the cheque and said, yeah, here you go, you've got some shares. And the court said, well, no, that was too long. After 5 months, they said the offer to buy shares had lapsed and it could no longer be accepted by the company. Okay, what if you change your mind? What if I've offered to sell my car and then I realise actually I'm quite fond of it, I don't want to sell it? Well, that's fine. I can do that. I can revoke my offer. Revoke just means withdraw. And I can do that at any time, so long as you haven't accepted my offer. Because once it's accepted, remember, my offer is replaced by an agreement, by a binding contract. So I can change my mind, I can revoke my offer at any time before acceptance. But the rule is that revocation must be communicated to the offeree. And that just means you must know about it. Okay, now you may know expressly because I've told you. It may be by implication. It may be that you walk past my garage every day and you can see that that car is now gone from my forecourt. That would be okay, but you must know. Okay, now communication of revocation, again, the examiner quite likes this, can be by any reliable person. And it's difficult sometimes to know who is a reliable person. In the case that established this principle, the reliable person was an estate agent who was involved in brokering the negotiations. But it might just be someone who you know, someone who you can trust, someone who you expect should know what's going on. Quite often in the questions, it might be the brother of the offeror, or the flatmate is another one. Now, whether they are a reliable person depends really on whether you would expect to be able to trust them. Would you expect that person to know that I've changed my mind? Now, this point here is also worth noting. An offer to keep an offer open. So let's imagine I say I would like to sell my car to you. I'll offer to sell it to you for £20,000, and I will keep that offer open until next week. Now, if I get a better offer tomorrow, somebody comes and offers me £22,000 for my car, I might want to accept that offer. But I've promised you that I will keep my offer to you open until Monday. Can I accept the better price? Well, the courts say, yes, I can. Just because I've promised to keep that contract open, that offer open until next week, doesn't mean that I'm bound to do so. The only time I would be bound to keep my offer open is if I had a separate contract with you to do that. So let's rerun that situation. So I've offered to sell my car to you for £20,000. You've asked me to keep the offer open till Monday, till next week. I agree to do that if you pay me a deposit of, say, £10. Now, if that happens, we have a contract. We have offer and acceptance. You've asked me to keep the offer open. I've accepted, and we have consideration because you have paid me a deposit. Okay, now in that situation, I can't accept that better offer that I'm going to get tomorrow, the £22,000 one. I'll have to wait and see, first of all, whether you want to buy my car next week. Now, the final situation when my contract, my offer may come to an end, is on failure of a precondition. Now, this is where I've made an offer that says I will sell my car to you if I win the lottery on Saturday. Okay, I've made an offer to sell my car, but I'm only going to sell it if I win the lottery. Okay, so when Saturday comes and I don't win the lottery, my precondition has not been satisfied and therefore my offer will lapse. Okay, so that's an explanation of the law surrounding an offer. We then need to have a look at the law surrounding acceptance of an offer, and we'll do that in the next lecture.